Hi, welcome to Cal Divorce, your one-stop shop for free information on how you can get a divorce without a lawyer. In this video, we will show you what steps you can take to start the divorce process on your own in Los Angeles, California. California has 58 counties, with Los Angeles, San Diego, Orange County, Riverside, and San Bernardino being the top 5 most densely populated counties. In Los Angeles alone, the percentage of divorced persons is 8.2%. For the following counties: Los Angeles, it's 8.2%, San Diego, 9.9%, Orange County, 9.2%, Riverside, 9.3%, and San Bernardino, 9.5%. Shasta County has the highest percentage of divorced people in the total population at 14.3%, while Santa Clara County has the lowest percentage with a rate of 7.3%. Now, if you live in the city of Los Angeles or in Los Angeles County and want to get divorced without a lawyer, stay tuned for the steps on how to start that process. California is a no-fault divorce state. This means that the only requirement for a no-fault divorce is that the couple must state that they cannot get along. Grounds for divorce in California include irreconcilable differences and incurable insanity. California law allows for both contested and uncontested divorces. Contested divorce. If the parties cannot agree on the terms of the divorce or do not meet the eligibility criteria for summary dissolution, they may file for a regular divorce, also known as a contested divorce. In a contested divorce, the parties must go to trial to resolve any disputes over property, debts, and child custody. Uncontested divorce. This is a simplified process for divorce when both parties agree that the marriage is irretrievably broken. It can also be used when one spouse is unable to make decisions due to a permanent condition. An uncontested divorce can be completed more quickly and at a lower cost than a contested divorce, as it eliminates the need for a trial. Here is an illustration of an overview of the divorce process in Los Angeles County. It is free and downloadable through the following link. If you need to meet the residency requirement, fill out the divorce forms, file the form with the court, and serve your spouse with the papers. California Family Code Section 2320 sets forth the residency requirement to file for divorce in California. Requirement 1, 6 months in California. At least one spouse must have been a resident of California for at least 6 months. Requirement 2, 3 months in Los Angeles County. At least one spouse must have lived in Los Angeles County for the last 3 months. The purpose of this residency requirement is to ensure that the Los Angeles Superior Court has proper jurisdiction over your divorce case. If you do not meet the residency requirement, you may need to wait a while before filing. In our first video, we discussed in detail the forms you need to fill out when getting a divorce. You may click the link below to watch that video for more details. You need to prepare the following forms: the petition, form number FL for Family Law 100, summons, form FL 110, declaration under Uniform Child Custody, Jurisdiction, and Enforcement Act if you have a child under 18 years of age, form FL 105, proof of service of summons, form FL 115. Please take note that for preliminary disclosures, you must share financial information with your spouse within 60 days after filing your petition. You need to prepare the following forms to share financial information: Declaration of Disclosure, FL 140, Income and Expense Declaration, FL 150, Schedule of Assets and Debts, or Property Declaration, Form FL 142 or FL 160, Declaration regarding Service of Declaration of Disclosure, Form FL 141. You must complete preliminary disclosures by a certain deadline: 60 days after filing a petition, if you're the petitioner, 60 days after filing a response if you're the respondent. The financial documents don't get filed with the court. You just share them with your spouse. Then file a form with the court to let the judge know you met the requirement. Declaration regarding service of declaration of disclosure at the following link. This form tells the court you sent the required disclosures. Make 2 copies of this form, go to the same courthouse where you filed your initial divorce papers. At the courthouse, file the form by giving the original and 2 copies to the clerk. The clerk will stamp the form, the court will keep the original and return the copies to you. One set is for you, the other for your spouse. File the forms with the court. You need to file the divorce petition by taking the completed forms mentioned earlier to the Los Angeles Superior Court. Specifically, you will file the papers at the Family Law Courthouse. Here are some useful links to important websites. The Los Angeles County Superior Court website, lacourt.org, Self-Help Services with the Court, lacourt.org/self-help/selfhelp.aspx. Los Angeles Family Law Courthouse, lacourt.org/division/family law/family law. At the court, you'll file the forms you filled out by giving the original and the 2 copies to the clerk. Here is some information that might come in handy. Los Angeles County Superior Court, Family Court Services. The address is 111 North Hill Street in Los Angeles, California, 90012. The website is www.lacourt.org/division/family law. Hours: open Monday through Friday, 8 a.m. to 4:30 p.m. Appointments are also available at 7:45 a.m., 9:45 a.m., 12:45 p.m., and 2:45 p.m. The office is open from 7:45 a.m. to 4:30 p.m. Phones, including PACT program, Parents and Children Together, Service Intake and Administration, telephone number 213-974-5524, Parenting Without Conflict, Info Schedule, Service Intake, 213-974-5524, extension 3, PACT program, Info and Schedules, Service and Intake, 888-889-990. Pay the filing fees. The filing fee costs between $435 and $450. If you cannot afford the fee, then you can apply for a fee waiver using Form FW001. Using this form, you can ask the court to let you file papers and receive court services without paying court fees and court costs. Because A, you are getting public benefits, B, you are a low-income person, or C, you are indigent and do not have enough income to pay your basic needs and your court fees. You can obtain Form FW001, Request to Waive Court Fees, by visiting this link, selfhelp.courts.ca.gov/fee waiver. See our separate video on how to apply for a fee waiver. Personal service. When you serve papers, it means that another adult, not you, hands your spouse a copy of the filed papers. This person is your server. Your server must complete a form and file it with the court to prove they delivered the papers. Choose a server. Your server must be 18 years old or older and not a part of your case. Your server can be A, someone you know, B, the county sheriff in most counties. The sheriff charges to serve papers unless you have a fee waiver. A professional process server you hire. There are some situations where you need to use a different process. Common examples of these situations: you don't know where your spouse is, or your spouse is in another country. Figure out when to serve. Once they are served, they have 30 days to respond. After that, your case can move forward even if they don't respond. If, after trying to find your spouse, you still don't know where they live, you can ask a judge to let you serve by publication or posting. Then you can move forward with your divorce. Have your server give the papers to your spouse. Your server must find your spouse and hand them those forms. Copies of forms you filed with the court, except any fee waiver forms, a blank response for marriage, domestic partnership, Form FL120, blank response forms if you filed other papers. Your server should note the address where they gave your spouse the papers along with the date and time. The server needs this information to fill out a proof of service form. You can download the proof of service form here. Have your server complete the proof of service form. You can use proof of service of summons form FL115. Your server can then fill in the information about how, when, and where they serve the papers. Your server must sign the form. Make a copy of your proof of service form, file the original and copy with the court where you filed the papers. The court will stamp and return the copy. Keep the copy of the proof of service form for your records. Once you've served the petition and summons, you've completed the first part of the process to get a divorce. The spouse has 30 days to respond to the divorce papers. If your spouse agrees to the divorce, they may file a response form FL120 found at the following link. If you are responding to the divorce as the respondent, you must share your financial information 60 days after filing a response. If you did not file a response, but you want the court to approve an agreement called a default with agreement, you also must share your financial information. What if your spouse doesn't respond to the papers? If your spouse doesn't file a response within 30 days of being served, you can ask the court for a default. This means asking the court to decide the case without your spouse's input. We will have a separate video about the process for divorce by default. File the forms mentioned earlier, forms to share financial information. Once you've completed your preliminary financial disclosures, shared them with your spouse or domestic partner, and filed proof with the court, you have completed the second part of the divorce process. To finish your divorce, you need to decide how you'll divide property and debts, whether anyone will pay spousal support, and how you will care for and support your children if you have any children. You can do this by working with your spouse or domestic partner to reach an agreement. Once you reach an agreement, you'll write down that agreement. If your spouse isn't participating, you can make decisions without their input. If your spouse never filed a response and the two of you do not have an agreement, that is, if you're getting a default divorce, you can tell the court in writing what you want without your spouse's input. The court will still need to approve what you ask for. If you can't agree, you can ask the court to decide. But what if you need something before you reach an agreement, like spousal support or child custody? Then you can ask the court to make a temporary decision, issue an order about your finances or family situation while the divorce is ongoing. There is a self-help guide about requesting such orders at the following link. Once you have made decisions, you have completed the third part of the divorce. To finish your divorce, you must turn in a set of final forms. If you have any court orders or an agreement, you submit those as well. The court will review these forms to be sure nothing is missing and no mistakes are on the forms. If not, the judge will sign the final form, the judgment. If you ask for a divorce, the judgment will state the exact day your marriage or domestic partnership officially ends. The steps you need to take and the forms you need to fill out vary a bit depending on if there's a divorce, if you have a written agreement, or if your final orders address child custody or child support. Depending on your specific situation, here is a step-by-step guide with the following link to the self-help unit. This guide also comes with links to forms that you need to sign and submit to the Los Angeles Superior Court. These are the general steps to finish your divorce, whether or not you have a default, an agreement, or had a trial. So fill out the forms, fill out the final order to end your marriage, that is a judgment, along with other forms. Submit the forms to the clerk, make copies of the forms and prepare return envelopes. Mail or bring the forms and envelopes to the clerk. Wait, a judge must review your forms. If everything is correct, the judge will sign them. Receive the signed judgment. You will receive the signed judgment in the mail or pick it up at the court. Once all of these issues have been decided, you can submit final paperwork to the court and your divorce will become final. In our next video, we will discuss the steps on getting a divorce for the other counties in California. Stay tuned. This video offers you free information on how to start your divorce in Los Angeles, California. This video does not offer legal advice or create an attorney-client relationship. If you need help with any step of the process, please consult an attorney or one of the self-help resources mentioned in this video. If you like this video or if you were able to get some valuable information, please like and subscribe to our channel and leave your comments below. Feel free to suggest topics you want us to discuss in our next video. Thank you for watching.